Warner Chappell Music Inc. et al. Versus Nealy et al. 2023. Under the Copyright Act, plaintiff must file a suit within 3 years after the claim accrued. One interpretation of the claim accrued is when the act took place, versus another interpretation of claim accrued is when the plaintiff discovers it. This allows a plaintiff to make a claim about something that happened a while ago. Nealy sued Warner Chappell Music for copyright infringements that goes back 10 years. Warner accepted Nealy's discovery period, but claims that the damages can only go back over 3 years. In a 6-3 decision, the court stated that a plaintiff can sue after 3 years of knowing about the copyright violation. There is no time limit on monetary damages. Kagan, Roberts, Sotomayor, Kavanaugh, Barrett, and Jackson joined the opinion of the court. Gorsuch, Thomas, and Alito dissented. Kagan wrote the opinion. The plaintiff brought the claim in a timely manner. This began in 1983 when Sherman Nealy and Tony Butler formed Music Specialists, Inc. The company recorded and released one album and several singles. Over a few years, the relationship dissolved, and Nealy went to prison for a drug-related crime from 1989 to 2000, and in 2012 to 2015. Butler, unbeknownst to Nealy, entered into an agreement with Warner Chappell Music to license the work from Music Specialist catalog. The music was then used by Flo Rida's song In the Air and popular songs such as So You Think You Can Dance. Music was also used for other recording artists such as Black Eyed Peas and Kid Sister. In 2018, Nealy sued, stating that the infringement reached back to 2008. In the district court, Warner Chappell Music acknowledged the infringement, but wanted the damages to only go back for 3 years. The Court of Appeals for the 11th Circuit stated that Nealy did bring a timely suit, as the district court acknowledged, but the Court of Appeals stated that damages do not have a time limit because the Copyright Act does not specify a different damages bar for a timely copyright claim on recovering damages. Thus, if the suit is timely, then all damages should be recovered. Gorsuch wrote the dissent. The Copyright Act should be interpreted as 3 years after the infringement occurred, and not when the plaintiff is made aware. The plaintiff did not bring this claim in a timely manner, even though this was not the issue the court considered, since the plaintiff and the respondent did not argue over this point. Gorsuch further states, nothing requires, and I quote, nothing requires us to play along with these particular parties and expound on the details of a rule of law that they may assume, but very likely does not exist. Respectfully, rather than devote our time to this case, I would have dismissed it as imprudently granted and awaited another squarely presenting the question whether the Copyright Act authorizes the discovery rule. This case was a waste of the court's time, since it doesn't address the real issue of the discovery rule if this case was brought in a timely manner. Overall, the Copyright Act allows a person to sue for all damages as long as a person sues within 3 years of knowing about the copyright infringement.